you all for joining us today. My name is Tessa Molnar. I'm with Huski.ai. I work in sales, business development, and marketing. I'll be the moderator of today's panel. And while the rest of our viewers trickle in, I did want to give a little bit of introduction and background as to why Husky decided to organize this roundtable. Our founding slogan was protecting the ownership of originality. As generative AI gains popularity and becomes more accessible, the question then emerges, how do we credit creators? In simpler terms, who gets to take credit for AI-generated art? Is it the AI itself, the programmers who wrote the code, the person who clicked run, or do the rights perhaps belong to the creators of the art that was used in the training data? In this roundtable, we have a panel of experts from a broad range of disciplines who will be discussing these issues so that we can better understand the current situation and future implications. I'm very pleased to announce our exceptional panel. Please welcome first Professor Philip Yu, Distinguished Professor of Computer Science at the University of Illinois, Chicago, and the Wexler Chair in Information and Technology. Professor Yu is currently the 7th most cited researcher in the world for computer science. Next, we have Professor Nicole Morris, Professor of Practice at Emory University School of Law. She's the director of Emory's TIGER program, which stands for Technological Innovation Generating Economic Results, and the director of Innovation and Legal Tech at Emory Law. Professor Morris was also honored as a 2022 ABA Women of Legal Tech for her leadership in the industry. We are pleased to welcome Leo Liang, head of data platform and services at Coinbase, one of the largest and most widely used crypto exchange platforms. He's an engineering leader, entrepreneur, and an investor in Web3 and AI technology in Silicon Valley. We have attorney Michael Geller joining us. He is a partner at DLA Piper, one of the world's largest law firms. Michael focuses his practice on trademarks and copyrights, brand management, and more. He was recently recognized by Huski.ai's 100% data-driven ranking of top trademark attorneys with a Web3 specialty. And we have Peter Donahue, our artist on the panel. As if being an educator, graphic artist, cartoonist, designer, writer, and creative entrepreneur weren't enough, Peter has also become a TikTok sensation for his viral educational content on color theory and currently has over 300,000 followers. Welcome, panel. I'm really excited to be here. Our audience today represents also a really wide range of disciplines and quite a global presence, from well-known companies and brands to law students to artists to Silicon Valley tech junkies. We're all here with different levels of expertise in different domains. So without further ado, we can get started. Professor Yu, would you mind starting us off and telling us what is generative AI?
Okay, so basically, generative AI use data-intensive AI capability like deep learning and neural network to recognize underlying pattern in different types of books, articles, photos, drawing, and paintings gathered from a massive collection of digital sources. Based on keyword prompts, generative AI platform can then mimic these sources to produce fanciful story and picture of their own. So the interesting question is that why is generative AI started to become popular now? It is because some of the recent development, for example, we have this advance on deep learning technique. And we also have an availability of very high-powered GPU. And also in this big data era, we're now having massive amount of digitized data. So with the data and the algorithm and the hardware, GPU, So we are able to do this.
Interesting. Okay. So it's just now that we've caught up with the ability to do this.
Yes.
Cool. So then before we get into any controversy, and we have plenty of controversy to address, it's worth noting that generative AI is currently hotter than ever. We even use generative AI to write the Eventbrite description for this roundtable. More importantly, though, investors are pouring tremendous amounts of money into generative AI technologies. Multiple startups have recently raised over $100 million in their seed and Series A funding, achieving the coveted unicorn status. And for those of you who don't know, a unicorn is a startup that's valued at $1 billion or more. Leo, would you mind sharing with us why investors are so excited and intrigued by generative AI? What's the appeal and what are the expected returns?
This is yeah, thank you. Can you hear me?
Mm-hmm.
Okay, this is actually a really good question because in the recent years, right, the model size become much bigger. So the machine learning model, right, that means also the modeling technique actually increased. Our model already really good at generating patterns or mixing up the pattern that they have seen and generating into very meaningful content, okay, using some constraints. That means what? That means generative AI can help you to write, can help you to not just write text, right, but also actually do the painting, as well as actually compose music, etc. If you really look into some of the recent investment, for example, Copy.ai, or Rigid.ai, they actually raised at least $100 million, okay, for their ventures. Reason being is because we all actually seeing the generative AI is doing an exceptionally good job in certain set of workflow. For example, Rigid.ai is really good at writing go-to-market blog posts, right? Or the content for that. The content itself that actually written for that is fairly, for me as a English is my second language, right? Like when I just look at that, it's amazingly well written. Okay, just put in that way. That means it's like the AI is already good enough to, I won't call that replace human at all. I would just call that is in the auto helping the human in the co-pilot mode to actually finish some of their major daily tasks. And let's look at another example for that is if you use GitHub, right? If you are actually an engineer, and GitHub Copilot can help you to finish your code. So you just actually writing out a description of what your piece of code want to do. They will quickly actually suggest a batch of the code written to fulfill your goal. The accuracy, it is like 60%, 80% correct. And this is actually largely accelerating the engineering effort as well. So far, the generative AI is not just for writing text, but also actually suggesting very delicate, complex tasks as well. And for now, that's why so many VC actually flush into this particular area, because all this small work actually can be replaced. First, we replace every single step or some of the step that human not terribly good at or require specialty to actually do that. And then if each of the step can be replaceable, and we will have an end-to-end whole UI or AI automations, right? If you really think about this is actually huge. When you talk about early investment, how much investment return for this one, it is very hard to answer for this. I consider like generative AI at least actually have 10 years to go in order to actually getting into really into the end-to-end mode that we talk about. But once we actually get into that, this is a multi-trillion-dollar business. Yeah, that's actually my thinking about this.
That's very interesting, very helpful insight. I think we will definitely probe further on some of the points you brought up as we go. I do want to address, though, right away, one of the most contentious issues and what we promised in our title. The first issue is who can claim to be the creator of AI-generated content? Can a machine be a creator? So Professor Morris, can you shed some light on the legal perspective? I know, for example, the US Copyright Office and the Patent Office have issued pretty clear stances requiring that an author must be human. Can you fill us in on some of the basics of copyright law, like authorship and ownership, and share with us some more details about these filings?
Yes, happy to. As you mentioned, the recent rulings from the US courts and the USPTO and the US Copyright Office have made it clear that for AI generated or AI assisted inventions or creations, you must have a human identified as the creator. The copyright law has been clear on this issue probably for a really long time. Copyright and patent law find their foundations from the US Constitution. Specifically, we see in Section 1, Clause 8, that the protection of intellectual property as it relates to copyright and patent law was set up in our Constitution, that Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. The key term or terms in that clause are who is an author and who is an inventor. And when it comes to AI assisted or AI generated innovation, that's the critical question. And what we see, at least with copyright, recently the US Copyright Office denied a request for reconsideration on a refusal to register an artwork created by AI. More importantly, the applicant noted that the artwork was created autonomously by the computer algorithm running on a machine. So there was never an assertion that there was a human author or creator involved with that work. And that's the critical point in terms of thinking about AI generated, AI assisted inventions and creations. Currently, the stance in the US is if you don't have a human in the loop, as they say in AI, the government's not going to grant you an exclusive monopoly right to that innovation. So for copyright work, it seems that that's kind of a closed case, right? You would have to identify who the maybe software algorithm computer scientist was in order for you to further identify a human in the loop for an artistic creation. We do allow copyright protection for algorithms. However, there's a limitation on the algorithm protection in the sense that the Copyright Office and the Copyright Act will grant you a copyright for an expression, but not for the idea itself. And if there's too much functionality in your algorithm and the expression itself cannot be retained or identified, you will not get a copyright. So you have seen lately in the Google v. Oracle case where the APIs were found to, the question on copyrightability of APIs was actually punted by the Supreme Court, but the work that Google was doing using the Oracle API was found to be fair use under the exception for copyright protection. So most legal scholars have taken that as a sign that, yeah, you can file a copyright for your algorithm, but it's more than likely that anyone using parts of that algorithm can make a fair use argument that they can still take parts of your copyrighted work and use it for some new creation. So the law is still a little fuzzy in terms of what is happening exactly with algorithms and copyright law, but for now, most legal scholars and most practitioners think that the case for copyright protection with algorithm has been weakened by the Google case. But as it relates to AI more specifically, you definitely will need to define a human as your author for your work, for the Copyright Office to recognize it. And then similarly for inventions in the Patent Office, the law is pretty clear that in order for you to be an inventor, you also have to be a human. And the case that you have here on this slide with petitioner, I think it's Thaler and the DABUS system, which was an AI, solo AI invention. The office was clear in terms of the Federal Circuit ruled that there are no solo AI inventorship. But what's not clear is what constitutes sufficient human contribution, because as we know, with code and everything else written in AI, there's at some point down the chain, some human author involved at some point. But when you get into fully autonomous systems, right, that and those inventions, it's clear currently, at least with the legal rulings that we have, that you cannot claim those AI fully autonomous inventions for patent protection. And I will just add that there's Australia and UK courts are also ruling in the same fashion, saying that only humans can be inventors for protection, patent protection in Australia and patent protection in the UK. For those who aren't fully versed in patent law, jurisdictionally, it's country specific. So if you want patent rights in the US, you have to file for US patent protection in the US. If you want patent rights in Australia, you must file those applications in Australia, and likewise in Japan and the UK, and so on and so forth.
Thank you. That was really helpful. It might make sense for us to jump a little bit further ahead. I'd like to ask you, Professor Morris and Professor Yu, about approaching the singularity and fully autonomous. If we truly achieve the ability for AI to generate content or to invent new things, will that truly with no human intervention, no prompts, Professor Morris, do you think that would change how the Copyright Office feels and approaches these issues?
No, not unless there's an act of Congress that really redefines who can be an author. So structurally, what we're dealing with is the question of how do you define an inventor and how do you define an author? And the courts have been clear that that definition requires a human. One of the nifty things, which is why I love patent attorneys, and I'm a patent attorney as well, you can have, and the US Patent Office has been granting patents for AI assisted or AI generated inventions. But the way you get around that is, it's part of the process, right? It's not that we're claiming solo inventorship with the AI. We are actually claiming inventorship with the human who is at least auditing, checking, verifying, working with the AI, and the AI component is only a part of the invention.
Thank you. And Michael, can you confirm with us how it would work if a human were to try to register an AI generated artwork for copyright protection?
No, I can confirm, because it's like Professor Morris said, it's a little bit of the wild, wild west, right? So she's 100% right that if you claim ownership for the computer, for the completely AI generated image, you're going to get dinged. The Copyright Office says you can't have a completely computer AI generated image and get copyright protection for it. Okay, so finally we have a solid answer on at least something. The question that moves us then into is, how do you get protection? And then it's having what Professor Morris was talking about in terms of having an AI assisted image that's made. Okay, that gets us into a little bit more of the gray area in terms of what's the AI's role versus what is the human's role. Now, I think that's something that's going to have to be specifically stated on the copyright application form. The greater the role of the human being, the greater the role that the human being has in terms of the originality in creating the image, in creating the authorship of the image, the greater likelihood and all likelihood that you're going to have in terms of establishing and being able to register your copyright. Some additional concerning elements in terms of drafting copyright applications and obtaining copyright registration is when you fill out a copyright registration, it's going to ask you, and I know we're going to get into a little bit more of derivative works, but it asks you, is there any underlying works on which this is based? And generative AI, a lot of times, is drawing from a lot of pre-existing art or a lot of pre-existing images or a lot of pre-existing material that are out there. And you start to get into the difficult question of what is causing either is the inspiration for the material, or has material just been straight copied? Inspiration, okay, that's fine if it falls along the inspiration side of the spectrum, but if it follows along the pure copying side of the spectrum without authorization, then you have potential infringement. Very much along the lines of what Professor Morris was saying in terms of the idea expression dichotomy. So that's going to be difficult if your AI software, your AI generating material does not log what's being copied and how it's being copied and whether it's just being used to draw some elements of inspiration or not. I think to the extent that there is a lot of dispute in the future in terms of AI generated images, a lot of it is going to boil down to that. What was copied? How is it copied? The extent to which it was copied. And even companies who are, image listers or image catalogers or image licensors have gone so far as to say, you know what, I'm just going to get out of this game for the time being. We're just not going to license AI generated images because it's too big of a liability.
It's really interesting and really helpful. Thank you. Thank you for sharing that. Related to that question of what is the role of the human and the role of the AI, Peter, I'd like to get your opinion from an artist perspective. Can a human using an AI generator call themselves an artist? For example, in early September, an AI-generated artwork won first prize in the Colorado State Fair's Fine Arts competition. And this decision did not seem to be very well received by creatives. For example, one tweet called it, and this is a direct quote, "Pretty fucking shitty that an AI-generated piece won first." Direct quote, that an AI-generated piece won first place. And this tweet didn't seem to be a fringe opinion. It has over 89,000 likes and over 17,000 retweets. So what's your take from an artist's perspective? Is a human producing AI-generated art an artist? And does AI-generated art hold the same value as human-generated art?
Yeah, thanks, Tessa, for the question. I mean, from my perspective, the art community seems to be, by and large, in step with some of the legal perspective that Professor Morris and Michael have been telling us, that, if there isn't a human behind it, it's not something that, from the legal perspective, we'd protect, and from the artistic perspective, that we would see as a piece of art, right? One way I think of this, and I've seen this image before and was not impressed, this prize-winning image. To me, it's not particularly good. It's not actually a very strong example of what you can do with Midjourney, which is the platform that the artist used to create it. So I think of it like, an unpracticed person can't just pick up a saxophone and create jazz, right? It's kind of the same thing here. There's good AI art and there's bad AI art. Knowing how to prompt the machine learning algorithm, knowing how to prompt Midjourney or DALL-E 2 to get the kind of image you want, that's an art in itself. It takes time, it takes patience, it takes skill, it takes some knowledge about how the algorithm processes language, right? So it is something like playing the saxophone that takes time and practice to actually be able to do. So creating good art with tools like this isn't something that an unpracticed person can just do instantly. I don't think a lot of people would call it that. And to my mind, that might be why there's so much negative reaction to this particular piece. This guy played around with this generator a little bit and thought, let's see what happens. But there are creators using these tools who are creating phenomenal work that I would call art, right? So to kind of answer your second question, right? Does AI generated art have the same value as human generated art? You know, I think I'd answer yes to that, but currently, based on where the technology is now, in the future, who knows? But currently, the products of Stable Diffusion, which is this style of neural network generating, like text prompted image generating software, products of this software that I've seen that I would call art are art because of the skilled creative labor that a human has put into it, right? You know, there are different people that I follow on TikTok that are using this technology in a very creative way to rotoscope animations on top of existing footage, to create these like dreamlike image sequences. And it's all really fascinating. And I think the response to that work in the artistic community is positive by and far. So yeah, I think it's not just that it's beautiful and interesting and weird because it is novel, because it's something that AI can do that artists couldn't do before. I don't see it that way. I think that the artists are using their skill and expertise as creative thinkers to guide, or to choose when to guide and when not to guide, right? These are all kind of creative choices that have to go into something that we would value as art. And good AI art, I guess, you know, in my sphere, what would be considered that would be that which still has that kind of human impetus behind it.
So Tessa, I'm going to jump you and ask Peter a question directly. Sorry, because I think this is really interesting. Peter, do you think that if this image that's on the screen now is what you call a better AI created art image, that tweet there has less purchase, has less likes, has less, or is it?
Yeah, so that's an interesting question. I think it's got to be a combination, because this account, I don't know this person, but I'm not sure that that's somebody who represents the opinion of the art community.
Okay, that was kind of like
pursuing this, right? But then I think, again, the quality of the artwork may have had a different response. I think the issue here was not the art itself, but the ignorance of the competition judges. You know, this feeling of, you know, wow, this is cool. We don't understand what went into it, so we're judging it based on a set of standards that actually doesn't apply to what's in front of us. And I think that reaction is more to one of dishonesty than to the art itself.
Sorry, Tess, couldn't help myself.
Oh, no, please do. I jump in, interrupt me. Michael, I do want to confirm with you, though, there is a claim that work doesn't have to be good to be copyright eligible, right? You can get a copyright for bad art.
Yeah, unfortunately, that's right. And there's lots of, I'm an armchair expert on this because I was a art history minor in college, so I'm self-proclaimed expert now. But yeah, you're exactly right. It doesn't have to be good. It has to be original. It has to be original, and it has to be fixed. It's the original work of authorship that's fixed in a tangible medium. It does not have to be good. Professor Morris said that she's a patent attorney. She'll tell you that you can get a patent registration for a for a machine that doesn't work either. Doesn't have to work, and it doesn't have to be good. So you could get a registration for doodle with squiggles as long as it has sufficient originality.
That's exactly right. You know, I tell my students all the time, there's lots of silly patents out there, right? And in terms of, you know, commercial product versus your patent filing, usually patents are filed pretty early. So you may want to revisit and file some additional applications because you want to make sure you're capturing something that works in your patent filing. And similarly with the artists, yeah, you know, one of the interesting things I think about the Andy Warhol case, and you guys who follow what's going on with that, brief primer for everyone else who's like, what is she talking about? Currently in front of the Supreme Court, the Andy Warhol Foundation and a photographer by the name of Lynn Goldsmith are in a battle over a copyright of a photo that Lynn took of the artist formerly known as Prince, who, when he was alive, she was working on sort of like a new artist expose and was hired to take, you know, like 7 or 8 photos of him. She took these photos in black and white. I think it was Vanity Fair, guys. Am I getting the right magazine correct? Who then gave one of those photos to Andy Warhol and hired him to sort of provide a more provocative take on it. And then when Prince passed away, all of these sort of images and artworks kind of like were published, and it became known to the photographer that there was this other body of work, arguably a very, for the most part, all of us are agreeing that it's a derivative work of the underlying photograph, and whether or not Andy Warhol's use is considered fair use. Well, when you think about what's happening with AI and where you can potentially go down this path, and Michael was great about it in terms of AI is really using data, right? But in the context of this creator framework, it's other people's artwork. Like, you're training the algorithm on the work of others. And at some point, there really is a question of, is it direct copying? Is it arguably a derivative? It's probably a derivative of multiple works, which further complicates the issue of whether or not you should have an independent copyright that's created from AI generated work. But I think that takes us back to why the courts, at least, have been really resistant if they can't identify a human. Because as you think about how quickly this becomes really complex, that's the problem. Like, that's, you know, where do you sort of, if you think of, I think of it in terms of tracing, where do you trace the, you know, original work of authorship fixed in a tangible medium to when you're now scanning, you know, training data over 100,000 images?
And just to take that one step further, that's part of the problem in terms of, that's one of the main concerns, is that someone goes out there and generates a bunch of AI created content and then is able to basically monopolize the field of art by saying there's no more inspiration that isn't mine, right? You're seeing a little bit of that happen in the music industry right now with the proliferation of SoundCloud and Spotify, and everybody's got a place to publish their music such that you can go into almost any song and say, oh, I can find a little bit of inspiration from that song for this song. So you've seen a kind of proliferation of cases in the music industry, kind of tying one piece of song to that. I think the concern is that extrapolates into the art world here, the kind of physical art world with this.
That's very, very insightful, very helpful. Could a creator take a case like that to court? Is there a way that they can allege, or would they have some sort of basis to say my work was copied via this AI production process?
Yeah, I mean, it's gonna be very similar, I think, to the process you have in music litigation, where you take a short section of the song, you play it up one against the other, and then you have an expert say, is it inspiration or is it copying? You're going to take a section of the AI generated art, and you're going to say, and you're going to point it at, you're going to take this little section of it and point it out against this little section of the original and say they look exactly identical. And is that inspiration or is that an acceptable amount of copying? And there's probably going to be, lots of junior associates in litigation digging through all kinds of documents and code saying, where did that piece of, where did you scrub that that art from? Did you take it directly from the source? Can you tie it back to the source? And if you took it back to the source, is there a defense, right? Is it a smiley face that is what we call, a scène faire, that is basically just a repeated image over and over again, such that you really don't have any protection in that kind of image? Or is it something that's more protectable? So yeah, I think that's one of the concerns, is that, again, you're going to collect someone who's going to collect all of the stuff and be the troll and say, all of this inspiration is mine, and I'm going to sue you out there that try to copy it, because all the inspiration is mine. Anybody else is just copying.
Can I jump in and bridge off of that? I'm hearing a lot about the idea of a derivative work and what's fair use and all of that, and thinking about my very limited knowledge. So maybe Professor Yu can jump in as well. But my understanding about how stable diffusion works when it's translating a text prompt into an image is actually what it's able to do is what we would think of as genre, right? It does that extraordinary well. So for example, if you type in like, do it in the style of dystopian science fiction, the way that it's processed all of its training data has connected those terms to certain visual tropes, right? Certain things that are next to each other frequently, let's say, in those kinds of images. And so you're not actually going to be able to take a microscope. This is, again, in my limited understanding, and say, okay, if I compare this section of this piece to the derived AI generated work, you're not going to see anything that looks exactly the same. It's not that kind of copying, because it's generating something based on a set of rules which it derived from that work. So there's this step in between, right? And so the fact that it's doing actually what human creators do, just better and faster. When somebody says, well, I want to write a neo soul song, well, what are they going to do? They're going to train themselves on the data of the existing examples of that genre and then create something new. And I think that that's where it becomes something that is going to be very difficult for somebody to make a copyright claim against.
Yeah, but
I mean, I think it's going back to Michael's point about laissez-faire, which is sort of this doctrine that says there's certain types of expression that lacks the quality of originality. I don't have all my like legal ease in front of me, but basically it's something that we've now deemed to be more in the public domain, right? So one of the examples we talk about in my class is this notion of like cops and robbers, right? When you're writing literary work, that's not limited to just one, author, right? You see lots of cops and robber drama on TV, similarly with the hospital shows, right? You can have multiple versions of Grey's Anatomy, but the particular characters that are on Grey's Anatomy, you can't copy and take those. So, hospital genres. So the notion of what is a genre is really at play here when you have these AI assisted tools, because it takes that and now makes everything a genre, right? So now sort of scientific dystopian works have to have a particular expression with some particularity to say that that's your original work of authorship, but someone else can have something that also feeds into that same genre, but maybe their spaceship is blue and your spaceship is yellow.
Right.
And they're two independently created works, right? And I play a copyright lawyer on TV, but my real world is patent law. But that's one of the, to me, mind-blowing and also equally frustrating aspects of copyright law, right? That's how you have lots of works kind of in the same categories, but they're all independently protected as copyrightable works. So I'd love Michael's take on some of this as well.
yeah, I mean, this is a law school hypothetical. You've probably written exams on this, Professor Morris, right? It's like what's that line between genre and protectable expression that's original enough to have some kind of element of protection around it. You're absolutely right, Peter. I'm simplifying it. It's not that you're taking a pixel from everybody's different art and copying it on there. Though you could do that, I'm sure it'd probably be really, really cool. But maybe that's something you can do on your own time. But yeah, it's diffusing it and it's taking inspiration from it. The question at a certain point that's going to come up in certain elements of art potentially is, are you diffusing it enough, right? To bring it back to a little bit more of a kind of tangible example of a song. If I hear a song and the chord over, it's a combination of 10 different chords and I like the way it sounds and I'm like, I like that, but I'm going to be inspired by it and change two of them. Is that enough? Maybe it is, maybe it isn't. You're going to have an expert that comes in to say, no, it's not enough. And then an expert on the other side to say, oh yeah, that's a very typical progression in rock music to go that way. You might have experts in the art field to say, no, it's very typical to have this kind of genre of kind of a science fiction-y painting with, to go back to that last example of a queen in the front and everybody's looking in the background at a giant hole. And then an expert on the other to say, no, that's like, they're the first person to do it that way, and that's why it's original. So I think you potentially see infringement claims that are centered around that, and whether it's diffused enough, or whether the original inspiration has been copied enough. But you'll have a lot of those questions about where does it fall on that side of the dichotomy of expression versus idea.
Mm-hmm.
But it's a fair point. Yeah, it's not as simple as a one copy in most cases.
I think one issue that oftentimes comes up too is the money and is the time spent worth it? Is it worth it for an artist to try to assert that, or is it going to be so nearly impossible to prove that it's not worth someone's time or money?
I got kids put through college. It's always worth the time and the money of a lawsuit.
I was gonna give you a lawyerly answer, which is like, it depends. Yeah, no, some of these questions, like I think the question with the Andy Warhol case is, an important one. Does Lynn Goldsmith have enough money to take this case, through the Second Circuit back to the Supreme Court? Yeah, she's a pretty successful photographer, but even for her, this is expensive, right? Even for Lynn Goldsmith, like this is not a cheap fight. And I tell innovators, I work with innovators here in Atlanta a lot, mostly patents, but sometimes copyright, sometimes trademarks. And I tell them all the time, one of the things you want to think about when you're securing intellectual property rights, whether it's a trademark, patent right, or copyright, how and when will you need to enforce it, right? Enforcement of these rights is equally a critically important question that you want to think about on the front end, rather than you get to some endpoint. You're like, oh, I need to sue them, but I don't have any money, right? The enforcement of IP, particularly in copyright, I will say, people think patent law is hard. Copyright law is a little bit harder because the lines are blurrier, to use a blurred lines kind of, pun here. Yeah, there's lots more you can argue, which means you need really skillful lawyers like Michael and his team. And like he said, he's got kids to put through college. He's not cheap. So at some point you're going to have to get a legal team that, will be costly, or the fight is like 10 years, right? Like it's not in 2 years, this matter is done. No, they're going to appeal. They're going to win. You might lose and you want to appeal that again. And it's a long fight. So you've got to have the stamina and the resources to stay in the fight.
Yeah, these cases, they're just expensive. The lawyers are expensive. Sorry. The experts are definitely expensive. I can imagine that the people that are starting to think about this really carefully is whether this is covered by various insurance policies. A lot of times copyright infringement is not, but if you're running an AI generated image business, or if you're running an image business in general, you're starting to think about this, and you're starting to think about your insurance coverage as it relates to that. Because if you have a contract that says, insurance company, you're going to reimburse me for legal fees associated with XYZ if I get sued. And if that XYZ includes copyright infringement associated with AI art, either very explicitly or implicitly in a claim, then you've got the ability to take it pretty far, because the insurance company is potentially paying the fees associated.
It's very, very interesting. That was going to be my next question, is who do you even sue in the instance of copyright infringement from an AI generated work? Would it be the coder? Would it be the person who clicked go? Would it be the person who wrote the prompt? I mean, if someone doesn't have, say, some sort of insurance policy like that.
Yeah, I mean, practically you're suing whoever is going to be most responsible, and B, going to be able to pay out on the claim, right? was probably the person who's responsible for running, actually running the script associated with it. And then the person who is selling it, either displaying it publicly, selling images associated with it, sells it to Vanity Fair, sells it to Esquire, puts it in a gallery. That's probably who you're using as your reference point. But there's a lot of different people in terms of both. There's both direct infringement and there's vicarious liability. So, you could sue the person who made it and then the art gallery for potentially publicly displaying it as well, or something associated with that. To think more about that, depending upon the specific way it is. But yeah.
Very interesting. So in terms of Peter, were you going to jump in on that one?
No, I was just grunting in thought.
Oh.
That's what I do.
You're more than welcome to continue to do so. Professor Yu, I want to ask you a little bit about the remedies that might be available on the technical side. So let's say someone was sourcing protected imagery or some sort of protected works, and that was used in the training data. Unlicensed, it was wrong. Is there a way to teach a machine to forget what it learned, a sort of machine unlearning process?
Yeah, there are some research work going on machine learning, but this is still in its infancy. And then when we involve with the legal type of suits, right? Then there also is a question of there is a lack of agreeable metric to verify its forgiveness, right? For example, how do you verify that if the company say, okay, I already unlearned this this piece of artwork, right? So how do you really verify that he's indeed forgive this, right? Because art, this kind of thing, a little bit abstract because we are talking about styles, right? So it's hard to quantify or measure. So let's look at a case which is easier to understand, like classification. Okay, so let's say we take 1 million patients' mammogram to train AI machine, so the machine can look at a mammogram and say whether that mammogram has a breast cancer or not. Okay, then one of the patients say, okay, you have not got my agreement to take this take my mammogram to train the AI algorithm, right? So you should unlearn it. So what does that really mean, right? Because this mammogram with cancer, right? Maybe a lot of the mammogram with cancer are very similar. I mean, we trained with 1 million images. So whether we have that particular imaging there may not make any difference. Okay, it means that whether we include it in the training data or not included in the training data, it doesn't affect the parameter in the model. Okay, but let's say the company make an effort to maybe take that image out, right? Either forgive it or retrain the model. But how do you verify that indeed happened? So let's say if originally we take that patient's mammograms, right, as a test data and use the algorithm to make a prediction. If the algorithm say, okay, this particular mammogram image, we have 95% confidence that it have breast cancer. Now, after you unlearn it, the algorithm say now we have 80%, 85% confidence it has cancer. But is that sufficient for you to convince that the algorithm has forget that particular image because the confidence come down, or you think it should come down even more to 50% confidence in order for you to convince that it has forgive? So you can see that, right? There's no clear answer to this. To what kind of evidence you need to really convince that it has been unlearned, right? And in a lot of cases, whether you unlearn or not, it doesn't really change the model because we are training from a very large amount of corpus, right? Say like from 1 million paintings. So a single one doesn't really have that much effect on the whole thing.
So I think Professor Philip actually talking about on the very good technical, provide very, very good technical insight for this. It is so true on this. But let's actually step back a little bit here. I think we're getting into a philosophical problem, right? Steve Jobs actually once said, good artists copy, great artists steal. So that really means it's like human can learn from multiple sources and then blend in or reproduce some of their original work and then blend into a new product, right? So any successful product has to actually build on the previous successor. So that's number one, right? So, and the second part for that is, I think there's a bug actually in our law here. We try to draw a line between human and machines, right? Because of this drawing a line, that actually causing so many of these logical conflict in our sense. So think about that, right? If I am a human, I just actually learn all these actually great artwork from all these great artists, and then I produce my work that learning from them. And I think from the copyright law, right, that immediately saying, okay, I will be the one that originated, I own the copyright for the work. But the machine actually try to do the same thing that will yield different results. That's actually very contradictory in my opinion.
That's a really interesting thought. There was one tweet I was looking at in the sourcing material that claimed that that's actually what the difference is that humans have finite lifetimes and limited times to learn skills. I'm not saying that whether or not that's true, Peter can comment on that, but that is the inherent difference of a machine learning to recognize patterns and produce new things versus a more philosophical or emotionally intellectual component of humans creating art.
Sure. Oh, go ahead.
That's the point of having copyright protection at all, right? Go all the way back to the beginning here. Professor Morris pulled out, really there's North Star for this, the Constitution. And the reason we have protection for copyright, and the reason we have protection for patent is to provide incentive to artists and inventors to create, and that's a really good point that both Leo and Professor Yu raised, is what is the incentive for creation for a machine? Now you can push that back and say, well, the person who created the machine, what's their invention? But there is a little bit of tension there that's interesting. Sorry, Peter.
No, that's all right. I forgot what I was going to say.
Sorry.
Okay.
That's okay, because we do have a very important question to address, which is, and I would like multiple answers on this. In our lifetimes, will AI replace human artists? Is AI an existential threat to human creators?
Well,
Yeah, my view is that no machine can really replace artists like Picasso, Monet. People pay millions of dollars to buy their paintings, right? So because those painting is rare, right? Those people, Picasso, do not produce that many arts, right? So every piece is very, very expensive, and people buy it because of that name, right? It's not really on the content, because the con artist can also produce another painting very similar to Picasso's painting, right? But that would not worth a dime, right? So if you think about this, right? If a machine can produce millions of copies, actually, it will not worth that much money. So they cannot really replace the at least the high end of the art markets, right? Maybe they can win a piece, in those cheap art markets, right? If you just want to buy a $20 a piece of pictures, right? Maybe you buy it from the machines, right? But if you want bragging rights, right? You do not want the machines generating stuff. You want really the Picasso, the Monet, right? That's what I think.
Yeah, I'd have to agree with that, that I think it's the cheap end of the creative market that AI is going to influence. you know, this is kind of coming from somebody who's hustled a bit in those spaces as a freelance designer and illustrator and everything. You know, I don't think robots are going to replace human artists, but they're going to become part of the workflow of really niched down freelancers and people who are just generating revenue quickly by cranking things out. And, you know, like I've been in the Midjourney Discord, and I've seen all the prompts that people are putting in to get it to generate stuff. Some people are playing, but some people are trying to do work in there, like make me a logo for my company. And they're having a tough time getting anything they can use because, you know, if you're going to use that as a tool, you need to be somebody who kind of has some of the principles of design down in their experience. So those are the people who are going to leverage AI, these kind of like niche designers who are like cranking out $5 designs. And, you know, I think that's just going to intensify this trend that's been happening in the creative labor market already for maybe 15, 20 years, right? Freelancers can undercut prices like never before. And those who can hustle with AI as a tool in their tool belt are going to outperform those who can't.
Really interesting thoughts. Before we get into some Web3 topics, Michael, have you seen this happening in your trademark practice? Do clients come to you with logo designs and trade dress designs that were maybe built by AI, or?
No, not really. The area where we're most seeing this is we represent some NFT creators, and one of the big things in NFT now is to have basically you're branding an avatar and or a character kind of, and then you're using AI technology to build variations of that character. So one of the ones is like, if you consider like Bored Ape Yacht Club, there's a kind of prototypical original image, and then they do a bunch of variations off of that. A lot of people are using AI to create those variations. And the question is, you know, if you're using pure AI and you want to protect all of those elements that you've created, you're in a little bit of trouble, and you've got to then you've got to backstop and think, well, if copyright's not going to help me out, then what can I build into my images to create stickiness on either a trade dress or trademark front to make sure that people aren't copying your image and copying your character without authorization and leaving you with some kind of claim against them. Of course, NFTs and Web3, which we're going to talk about in a minute, has that decentralization element, which kind of butts up with head-to-head with kind of traditional IP rights, but I won't go too into that because I know we're going to talk about a little bit about Web3 too.
No, I mean, that is then a really perfect segue. So thank you. I was going to ask Leo to kick us off on Web3 and telling us what is Web3 and what are people talking about when they drop buzzwords like decentralization and blockchain.
Yeah, thank you. So what's a Web3, right? Web3, it is a buzzword, okay? So in my opinion, there's no clear definition what Web3 is, and this is just like all the buzzword. For me, for Web3, it really refers to a new class of applications, which is a blockchain application to me. Web3 here is not to replace Web2, just like Web2 is not there to replace Web1. It is a new class of applications. If in Web1 is user can read, Web2 user can write, which means contribute the content. For Web3, user can own the content and making the content actually very explicit. Since Web3, it is building on the blockchain system. Blockchain, it is not just a technology, but it is a whole kind of philosophy and the whole ecosystem behind it. For building on the blockchains, what does it mean? So it means you have the transparency. By the way, transparency doesn't mean lack of privacy, okay? Number one, it has transparency. Number two is you can build trust on top of these transparencies. And number three for that is payment. It is a native element in the technology itself. Okay, so Web3 automatically embed the payment. So if you say, hey, if you're using a Web3 app, then they're still popping up for you to use a PayPal and Stripe. I'm pretty sure that's not a Web3 app by definitions. And also for the Web3 is the ownership. It is explicit and verifiable. And last but not least, this is the most important part is, I understand that a lot of the time that our thinking and our culture is very, very US-centric. For Web3, we need to just think about global. And it really have a very deep implication about how we think, how we do. Especially when we talk about law or legal stuff, right? And always have the jurisdiction boundary. So when things actually in the Web3, we need to think about global, and that will actually have a lot of implications, not just on the economic and the marketing itself, but also for the legal itself. So yeah, that's on the high level for the Web3 stuff.
Really helpful. Thank you. Michael, so we will now turn it right back over to you. You can tell us a little bit about what you've seen in your practice and how is Web3 and decentralization, how is that affecting IP rights holders?
Yeah, so all really good points that Leo makes, and he actually describes Web3 as opposed to using it as a buzzword, which a lot of people are, right? A lot of people are using Web3 as a buzzword, metaverse as a buzzword, without really understanding what it is. So one of the big elements of Web3 in my mind is this ownership element. You own materials. And so decentralization is basically the concept of you don't have a top-down system of so Web2 would be something associated with, like, you post on Twitter, it completely lives on Twitter. You don't necessarily own the content, you're just using the platform to post your material. Whereas on Web3, you would have your own outlet, either your own domain or your own materials. But that Web3 element and that decentralization element starts to put ownership in each individual person's hands of various bundles of IP rights. And it also, to Leo's point, it starts to evaporate the geographic borders. That's troublesome for two different reasons, right? IP owners are going to want to jealously and aggressively protect their brands. And the way they do that is on the current landscape is on a, like Professor Morris said, country by country basis. So same thing as patents, trademarks are on a country by country basis. So if you have your trademarks registered in the United States, you don't have your trademarks registered in China, then you are out of luck. So people are going to increasingly start to think about how to protect trademarks with this kind of government overlay in this decentralized universe. And as we progress into more decentralized universes, how are brand owners going to basically take the existing structure that exists, existing laws, whether it's country-based or whether it's kind of platform-based, and introduce those structures into a decentralized universe, and there will be inherently some pushback.
Yeah, that's exactly right. There's definitely friction. And we're seeing that now with some brand owners trying to enforce, new platforms in Web3. And in some instances in the trademark rights, it seems kind of simple. I think of like StockX and Nike, the Meta Birkin versus Hermes. But on many levels, it's not, right? So, this question of, are consumers really confused in a decentralized world, right? Like what's the likelihood of confusion argument for trademark, to me, is interesting when you think about a decentralized platform, because your unit is so much smaller now. And survey evidence and all the things that we relied on in more of like a Web2 format, some of it can transfer over and translate well, but others it's like, I don't know. I mean, unless it's really those users who are savvy enough, like I've never been to wherever this place is for the Meta Birkin bag. So am I considered part of that, group? Would I be confused? Again, law school, hypothetical kind of questions. And then the marketplace, to Leo's point, like all of those transactions are fairly locked tightly within Web3. So if there is a question for you to, pull up your PayPal, where are you? Like, are you really Web3 or is this really Web2, Web3 kind of connection? I think they're fascinating questions. I understand how brands are being territorial and filing now, metaverse type trademark use applications, because it's not clear whether the existing applications that they have for what we would call brick and mortar Web2 commercial transactions would necessarily govern what happens in Web3.
Interesting. Does anyone else want to jump in on that one?
I want to chime in here a little bit here. In our IP law, we actually said that the ownership of a particular copyright must be human, right?
Yes.
And then in the blockchain world, we now have robot, in some senses, a smart contract, owning the asset or owning the right of a certain kind of asset or owning a creations as well. They're actually making the whole thing really, really muddy. I can consider this is a bug of our existing system.
Yeah, so it's interesting. There's clearly patent protection for certain blockchain use cases. But when you think of a smart contract, it's really just a transactional verification, sort of exercise.
More than that, a smart contract is a program. Okay,
Right.
It's a program. You can consider in some way they can do something that very explicit, but it depends on the input. It depends on what you observe. In some way that on the blockchain, we have very explicit ownership system. They can certainly create things that with very explicit ownership owned by itself.
Exactly. So those programs in and of themselves, the likelihood, and I'm going to say likelihood because I don't know this 100%, of someone being able to claim a monopoly right through a patent for that is low, right? So you're going to have multiple players. What they're going to protect under any intellectual property doctrine will be the use of that in some overarching commercial scheme, right? I'm using smart contracts, blockchain for a method of doing or processing something else within my healthcare business model or within some other bigger medical device, kind of thing. We have a very, well, the law is changing, but we have now sort of corrected on business method patents in the USPTO. So you can't just more generically protect sort of business methods, the method of doing this, using a smart contract, blah, 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 where it's too vague and not tied to something with a little bit more specificity or a direct device application. So that's not to say, because I'm sure someone's going to find something that's more broad, that's not to say that there could be some IP right out there that covers something more broadly. What I'd like to see is what happens when that patent is enforced and people start poking holes at it. So, so one of the sort of ways that IP law is either, depending on how you look at it, either not keeping up or nascent in a way that's permissible, because we want people to build on these platforms and not lock it up in terms of ownership to one or two entities. I'm of the latter view. I prefer you have some specificity to the ownership right you're claiming, and it's a use case that you've built like a value chain for, right? So if you're Medtronic and you've got this body of medical devices and you're now using some smart contract way of managing, I don't know, defibrillation and patient monitoring or whatever, totally fine with you filing a patent application for that, right? What I don't want you to do is lock up, a programming language that multiple programmers would like to use to do the same thing.
Interesting. Leo, I was wondering if you could share with us a little bit about how blockchain might be able to be leveraged by creators or creatives who are looking to protect their work. So similar to how NFTs are and blockchain is being used in the luxury goods space to authenticate different pieces of the transaction. So the bag gets shipped to one location, they add whatever, they authenticate the fact that that happened on the blockchain, so there's a record. And that is being used for anti-counterfeit methods. I've heard the idea floated around before that if artists were to leverage blockchain to protect their copyright protected works, it could be more easily traced if it went through diffusion models and were found in derivative works.
I think this is a very broad question here, right? Number one, artists definitely can benefit with blockchain, but just like all the new technology itself, we cannot just think about. We should not just think about blockchain as a ledger, just keep track of who owning this, right? But we should, for artists, we should actually think about blockchain as another sales channel and another way for that to not only protect your copyright, but also growing your business. For example, a lot of digital artists nowadays are just selling NFT. So on the blockchain, they create the artwork, they upload it, okay, and then they have a record pinning on the blockchain saying this artwork belongs to him, okay, and then they actually mint NFT out from there, and they sell. When they actually sell the artwork, number one, when they sell the artwork, the whole transaction is on chain, so the payment actually built in and the ownership is very clear. And then the new owner will actually owning their artwork, and then in the subsequent sales for the artwork, and these artists will continue getting the royalty, which is impossible in the traditional world. Okay, that's number one. And then the number two for that is the question becomes much harder to answer. This how to protect your work and so that other people using algorithm to learn from your work, and also actually you also get the credit out from it. To be honest, I haven't been thinking about a really feasible way because it is just like you have your work, you present it out there and people enjoying it. While they actually enjoying it, they were actually learning it. It's pretty much like you cannot stop another artist or even a kid to learn how you draw, and then they actually draw themselves. It's almost impossible. However, our system may require, we may be able to just building up some sort of like data set. So people actually training, for example, stable diffusion, right? So on top of that, using the particular data set, they will actually give the credit. Whoever training the model out from those data set, they will give the credit to the data set owner. This kind of model may work, but that's a more on the generic AI data set, how the credit system work. So, yeah, thank you.
I believe we are at about time to start taking some audience questions, but does anyone have anything that they'd like to close on as a final remark before we start going to audience questions?
I think just really quickly, from my perspective, it's interesting to hear about these ideas about what you're saying about how artists might leverage Web3 technology, because in my experience, there's actually it's a very torn feeling in the art community when it comes to NFTs and all of this, because of in the last few years, digital art being stolen and kind of minted by someone else who didn't own it, and high profile examples of that kind of shook the art community a little bit. And then there's also kind of a hesitance about NFTs because of the environmental impact of minting them. So I think, while there are artists interested in that and how they can use that technology, there is also kind of a lot of negative feeling about it in the art community, which is interesting.
Let me start to answer this question by talking about the environmental impact. Nowadays, the environmental impact, because Ethereum already merged into the POS, proof of staking. So they no longer proof of work. So the energy usage already down 95% or something like that.
Oh, wow.
Yeah. So that's number one. Along the line, I think we should be very optimistic on the technology development itself. Okay, trust the people with the good incentive to push the technology forward as long as it has commercial value, which it has a lot. And another part for that is this is more like basically the question for that is artists has a really mixed feeling about the NFT because they worry about their work actually got stolen and then get unauthorized. By the way, this is exactly the problem that when we started to transit into e-commerce.
Right.
The traditional channel actually worry about, hey, you steal my customer, and then they denied it. But for those who actually embrace it, or probably putting the digital first approach, that will actually winning in the next cycle. I think I will actually encourage people to see in that way because, as I said, the whole NFT revolution itself, it gives you a lot of the things that are impossible for you to do. You get magnitudes more customers. Your work is being seen by multiple more people because one part for that artist building up their name, right, is very important. Yet building up their name, they need their work to be seen by a lot of the people. You need to have engagement. You need to have your own community, right? So all of this is really, really good at building from the blockchain itself. So embrace it. And oh, by the way, there is quite a lot of studio helping artists to doing this digital transformation as well. And also, digital and the physical, they are not mutually exclusive. We have some friends actually doing a physical piece of work, but they use high resolution scanner and make it become an NFT. Whoever actually buying it, they also actually pass along the physical work as well. Or you can actually have a physical work, high resolution scanning, and then after you mint it, you destroy the physical work publicly, right? That also create a buzz. And then in that way, like your work become purely digital or digital plus a physical mirror copy. So you can use the blockchain to track the ownership and continue gain the owner, the loyalty. It's an opportunity, just to put it that way. Yeah, that's all on my end. That's all.
Thank you for that perspective. Thank you.
That's awesome. And Leo, if maybe you could share with us some of those resources. I'm sure there are a lot of creators in our audience who would be interested in hearing about that. We have a lot of really interesting questions that have come in. I don't think we'll have time to get through all of them, but one of them that came up was, what about when the prompt includes in the style of Warhol? So someone explicitly typed in something that is copyright protected. How does that play out? Maybe
it comes back to the question of genre, doesn't it? Right? Everything can become a genre in a stable diffusion world, right?
Yeah, I think that's right, is whether you're inspired by somebody or whether you're copying them. If you're inspired by somebody and you're generally painting in a style that is inspired by them, you are going to be closer to the line. But anytime you're saying you're specifically inspired by a single artist and a single artist's work, then you are at risk potentially, in all likelihood. But yeah, it boils down to that the dichotomy between expression and
That makes a lot of sense. We did get a more contentious artistic question, which I thought would be really interesting for us to address. AI models have put all art in the public domain and removed rights. It's like open source, except that even companies create proprietary code and products. For some reason, when it comes to the art space and the way art is viewed and used, art is always deemed within the public domain. Not all code is open source. Look at what is happening with GitHub Copilot and the types of discussions going on. How have artists let themselves be so reduced and impoverished on the whole when engineers as a whole and industry continue to make money?
I think the two things are fundamentally different, right? Because art is something you want people to see it before maybe they are willing to pay for it, right? The software, you don't need to let people see your code before people is willing to buy it, right? So I think their usage model is very, very different, right? Yeah, also, no, for example, if we want to do the training, using training data to train a generated AI model, right? We don't really need the original artwork. Even a photo will do, because it basically just tell you how things look like, right? We don't need to be the authentic piece there to use it as a training data. Okay, so I think it's a kind of very, very different. Okay, but artists don't need publicity, right, before people want to buy their art, and people have to look at the art. The software, you don't show the code, you just tell them the functionalities, right? And people will buy it.
I mean, I don't want to speak for Peter because someone just called him impoverished. And but in my mind, it's just another step in the kind of commoditization of information and turning of everything into bits and bytes that is information in general. If you're upset about art being turned into data that is used to create more images, don't go on Facebook, and heaven forbid if you have car insurance, because every motion that you make in a car or motion that you make in your life in terms of health insurance is being turned into bits and pieces of data that provides more information for a company to either help you create a usable insurance platform for you, or B, figure out what the best model is for the insurance company. It's happening in the art world, it's happening in the music world, it's happening in the insurance world, it's happening in the data world, it's happening on social media. It is an information economy, and now art is just part of it. That's my impression.
Sure. I mean, I think if you have kind of an attitude toward art that it shouldn't undergo all these processes, you need to really, look harder at what the role of art is in society. Creative industries continue to grow. I mean, I've got students who are interested in getting into animation and all kinds of these other things that is a huge sector. There are careers to be made and money to be made in the sphere. I think we just have to stop kind of fetishizing our idea of what an artist is, because that's what holds people back.
Interesting thought. I think this was a really interesting question too that came in, asking, almost giving the idea of a class action suit for copyright holders. So as lawyers on the panel point out, lawyers are expensive. The general impression is that copyright suits are not as rich compared to patents, but be that as it may, there clearly is strength in numbers. Most vendors from outside the US are not schooled in American style litigation, but I suspect it is much easier to settle a case with big box retailers if they are sued on hundreds, if not thousands of pieces of IP at one time. How about IP pools and use AI for monitoring, sending out cease and desist letters, and managing the contingency lawyer network worldwide? Is that a ripe business or legal opportunity?
I think you can throw AI on pretty much any legal type of industry and probably make a little bit of money now if you can do it in a good way. It's kind of the hot thing. I mean, people are already using AI to monetize brand enforcement, copyright enforcement, counterfeit enforcement. Some of the products, some of the services in this space are they're really valuable. And people who have figured it out have figured it out well. In terms of the other side, whether you can, in terms of whether you can use it in terms of a class action lawsuit, I just don't know. Class action certification is often a really high hurdle. You need to put everybody, and I'm not a class action lawyer, so I'm probably going to get it wrong, but you need to put everybody in the same boat and have them basically on all the same footing. It strikes me as that might be difficult to do in this case. But yeah, I don't know.
So it would be on an infringement by infringement basis, not just a bunch of artists saying all of our work was infringed. Unless,
yeah, it strikes me that it would be difficult to put everybody on the same exact footing. I mean, like, right, a class action lawsuit is generally something of the sort of, you, Pepper Company, told us that it was 100% fresh ground pepper, and it's actually 98% fresh ground pepper, and every consumer experiences that kind of wrong in the same exact way. I don't know if you could do that in this case, considering that each piece of art is different. And it would be unclear how each piece of art would be incorporated after being diffused through, whatever AI code you've written into a different piece of art. That seems like it'd be pretty hard to me, but I haven't fully, that's super unbaked in this kind of jelly bean of a brain.
Yeah, I think that's right, Michael. I mean, the other thought I had in terms of what makes IP infringement somewhat difficult to do as a class action bundle is the notion of the analysis to figure out whether or not there was copying, right? So for copyright infringement, you have to look at whether there was any copying, and that test is fairly unique of an analysis. And if you have different pieces of work that you're trying to discern was there copying, the court's not going to pull all that under one umbrella, right? When you have class action suits, you tend to find them with product liability, where it's like everyone was harmed the same way, right? We all had the black pepper and had the same, problematic response. We can bundle all those together. But when you've got intellectual property rights and the analysis based on the underlying work might change, slightly, you're not going to be able to pull that in as a class action.
very, very interesting. Well, we are at time. But thank you everyone so much for joining us. I don't know if we will get kicked off. Anyone would be welcome though to stay longer, and I will email everyone the questions. And if you are an anonymous submitter of your question, we'll either try to publish answers somewhere online for you, or you can send us an email directly, and we will try to get back to you. So we have a lot of questions, a lot of great ones, and thank you all so much for joining us today. This was a really great discussion.
Thank you guys. This was really great. Leo and Professor Yu, that was helpful.
Thanks all of you.
Thank
Appreciate
you.
it.
Thanks,
Thanks,
everyone.
all of you. Bye-bye.
Yeah.
Thanks. Bye. I need to jump.
Bye.